This procedure is not provided for in law, but it has been developed through precedents. In the Black's Law Dictionary, the word punch is defined as to exonerate oneself or another of guilt. The dictionary illustrates that by saying, the judge punched the defendant's contempt, end of quote. The Supreme Court of India, in Praveen C. Shah versus K. Hay, Mohan and another, civil case appeal number 3050 of 2000, extensively discussed what the punch process entails, making reference to its origins. The court stated as follows: purging is a process by which an undesirable element is expelled either from oneself or from the society. It is a cleansing process. Purge is a word which acquired implications first in theological connotations. In the case of sins, purging of such sin is made through the expression of sincere remorse coupled with doing the penance required. In the case of guilt, purging means to get himself cleared of guilt. The concept of purgatory was evolved from the word purge, which is a state of suffering after this life, in which those souls who depart this life with their deadly sins are purified and rendered fit where nothing defiled enters. End of quote. The court even went further to observe that merely serving a sentence for contempt of court may not be enough to vindicate the authority of the court, and that the best result would be what the contemnor demonstrates when the contemnor demonstrates genuine remorse and seeks the court's pardon. That was a major consideration that this court took into account when it opted for a coercive order as opposed to a punitive order, as the intention of the court was not to punish Mr. Masengeli for the sake of it, but to ensure that the sentence the sentence restores the dignity and the authority of this court. And the court intended to punish Mr. Masengeli right away, it would have not included the purge order as part of the sentence. The Indian Supreme Court, emphasizing on the need to have a sentence that meets the object or the aim of the court, held as follows: purging process would not be treated as completed merely by contemnor undergoing a penalty imposed on him unless he has obeyed the order of the court or he has undone the wrong. Next step is to seek pardon from the court concerned on the ground that he really had genuinely repented and that he has resolved not to commit any such act in the future. The apology tendered should impress the court to be genuine and sincere. If the court is being impressed in its genuineness, accepts the apology, then it could be said that the contemnor has purged himself of guilt. The question thus becomes, having listened to Mr. Masengeli, is the court satisfied that he is sincerely and genuinely apologetic about the circumstances that led to his conviction and sentence for contempt of court? In explanation, to exonerate himself, Mr. Masengeli stated on oath, giving an account in which he explained why he could not personally attend court on the 26th of August 2024, 29th of August 2024, 10th of September 2024, 5th of September 2024, and 9th September 2024, including the date of his sentence on the 13th of September 2024. He gave reasons that he was torn between national security duties and his obligation to attend court. He did not, however, explain why he could not commit to attend court on the day he had actually indicated he would attend, that is on 9th of September 2024. He was cross-examined by advocates for the petitioners, and my observation is that his answers appeared genuine. He was calm and polite. To crown it all, he pleaded with the court, stating that if he had been wrong or made an error of judgment in prioritizing other exigencies of duty over the court summons, he sought forgiveness and mercy from the court. He stated as follows, and I quote, "I want to apologize to this court and the judiciary for the events that transpired leading to orders of contempt of court. I respect you and the good work you do to uphold the law. As a police officer, it is my duty to enforce court orders and ensure court orders are obeyed. I pray the court accepts my apology, vacates the conviction and sentence. I so pray." End of quote. This court is convinced that Mr. Masengeli regrets and is genuinely remorseful for the situation he finds himself in. It is not the intention of this court to punish a genuinely repentant man who has acknowledged his mistakes and offered an apology. His conduct today has restored the dignity of the court and the due administration of justice by attending court and explaining the difficulties that caused him not to comply and offering an apology for any of errors of judgment he might have made. His undertaking to always obey and enforce the orders of the court came out strongly. The court is fully satisfied that the purging process has been infused in his mind, or in the mind of the contemner, Mr. Masengeli, the obligation to respect and uphold the rule of law and the due administration of justice. The supremacy of the law has equally been vindicated. To this end, I must arrive to the determination that Mr. Masengeli, through this purging process, has purged his guilt for the contempt of court, and thus both the conviction and sentence passed are set aside. I must, however, not end this deliberation without speaking on the need for all to respect and uphold the independence of the judiciary. It is the judiciary that guarantees adherence to the rule of law. Every Kenyan who means well for this country must fight for the independence of the judiciary so that judges can be allowed to make decisions based purely on law and the facts without the fear of reprisals, interference, pressure or threats, whether direct or indirect. That is the cornerstone of democracy. It should be known to all that the independence of the judiciary is not for the judges per se, but for the benefit of the public at large. It leaves judges with the discretion to make fair and even-handed decisions meant to uphold the rule of law. Judges must never and will never hold, judges will always hold government organs to account for adherence to the Constitution and the law, and it is the primary duty of the state to ensure judicial independence is protected. I am happy to note from that the 3 Kenyans, the subject of this petition, have been found. Having said so, and considering everything else, I am making my decision to recuse myself from the further proceedings of this case for personal reasons. I will thus be directing that this file be placed before the presiding judge for allocation to another judge. That's all.
State that we're very grateful for your patience. We're grateful to note that conviction and the sentence have been set aside. And on behalf of Mr. Masengeli, we wish to thank this court. Thank you. Thank you very much.
Hello, on behalf of the Honorable Attorney General, we want to most sincerely appreciate and thank you for the magnanimous sympathies you have expressed. You have actually appealed to the contemner. More so, my Lord, setting aside the conviction and the sentence, and therefore allowing Mr. Masengeli, who has served in this country with distinction in his career as a police officer, who has risen through the ranks to the level where he is now in charge as the DIG, in charge of police administration, and who I am sure from the mercies that you have extended will be able to continue serving this country, will be able to ensure that the borders of this country are secure, and the rest of us who are also been given this responsibility to serve in our various capacities will serve without any fear that we are under any threat. Suffice it to say, my Lord, that the aspects of insecurity in terms of the Al-Shabaabs and the rest are kept at bay by very committed officers led by by the DIG Masengeli, DIG Regard, and now the Inspector General, Mr. Kandi. We therefore, in a very special way, want to thank you, my Lord, and we will continue to uphold the rule of law. We will forever continue to ensure that court orders are not making pain, court orders are complied with, and indeed, that would enhance the independence of all the independent institutions. We thank you and we thank all of the audience.
Thank you. Moving from LSK.
Thank you, my Lord.
Mr.
Mr.
Mano.
We appreciate the decision of this court. We have also taken note of your closing remarks that you recused yourself from the petition hearing. And we had done an application for empanelment of a pre-judgment. The same is dated the 17th of September 2024. My Lord, so that we avoid the back and forth appearing before the PJ, we are seeking that if you can indulge us by allowing the application. It's our post from the state and not because the empanelment of the pre-judgment, considering the weight of the matter. We pray that you send it to the CJ for purpose of empanelment, waiting for 5 judges. Otherwise, we appreciate the court. Immensely, it has been a long period of back and forth before this court. My Lord, we are hoping that the rule of law will take its course, and perhaps going forward, our security officers will respect court orders. There is nobody who is above the law. Thank you, my Lord.
Lord, if I could make final submissions in this, we are extremely grateful for the court's time and resources in effectively working within a constrained time frame. Today, my Lord, we have witnessed the efficacy and the supremacy of the Constitution, the administration of justice, and even though, my Lord, the court has bowed either to the pressures or to the realities, the accused itself may believe has directed on our application, which is unopposed. Additionally, the Lord will give us directions on the main petition. We are very alive to the generosity of the court in accommodating the now purged DIG. We hope that this will serve as a lesson on state officers and public officers. Because without the law, then we are all equal to wild animals in the jungle. We're remiss of me, Lord, not to mention that why if not for the Law Society, then we will be pleading for costs. The full battalion of the Attorney General, my Lord, is here today, and the Government Proceedings Act still operates within a framework that we can realize our day as advocates in court. But we are sincerely grateful, my Lord, on the pressure that was present in this matter. The second petitioner, the third petitioner, and the fourth petitioner, as confirmed by the President Emeritus Nelson Harvey, were found today. And it will be important, my Lord, to try and get to the bottom of this so that they can personally attend court and explain to the court what actually transpired and who had them in their custody. From the Law Society, we are extremely grateful also to the participation of counsel. We witnessed a very spectacular moment where the DPP was supposed to condemn. But we live and learn, my Lord. From the Law Society, we are extremely grateful, my Lord, and we appreciate you. As you retire, do have a lovely weekend. We will take directions of the petition.
Okay, so now from the respondent side, do you have any objection to this matter being referred to the Chief Justice for empanelment of a bench?
No.
Now, considering my recusal, I will be referring the matter to the Chief Justice for empanelment of a bench with exclusion of Justice Lawrence Mugambi.
My Lord, we will keep on reporting from time to time to accept. You can be sure that we will be attending the court as officers of the court. I know
yes.
This is something that is recurring, but I have an obligation to my members so that if we leave here today, we hope that we back on money.
Lord, the President, I think, is but I just, my Lord, want to also appreciate and say, we confirm that we have not come here pretentious. We have come here as law-abiding Kenyans. The IG, the DIG, both two of DIGs who are here want to confirm that there is no threat to the lives of my colleagues, my Vice President of the Law Society of Kenya.
And Kenyans at large.
And the Kenyans at large.
Including the court.
My Lord, we also want to assure the court. Yes. We want to assure the court, my Lord, that your security is a prime responsibility of the two DIGs who are in court. I want to array entry to any Kenyan that indeed security is the primary responsibility of the state. And by coming before this court, and my Lord, I'm grateful and gratified that you observed the demeanor of one Gilbert Masengeli. I was personally touched, and therefore that assurance, the Vice President and my colleagues, Senator, you go rest assured that your security is assured. Thank you, my Lord. And we want to thank you for all that you have done for us. I'm sure today everybody will go to the weekend relaxed, and that the fourth estate will also spare Mr. Masengeli. Thank you so much.
Okay, so this file will be funded to the Chief Justice by the DR. The application for empanelment of a bench by the LSK is not opposed. Okay, it is allowed. This is a matter this is a matter of immense public interests and raises substantial issues of law. The file is thus referred to the Chief Justice for empanelment of a bench with exclusion of Justice Lawrence Mugambi. Thank you.